Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of consumer law, that too in relation to deficiency of service matters. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hello everyone, I'm Advocate Shweta Singh. Today we are going to discuss an important judgment titled as the New India Insurance Company Limited and Another versus SHASHIKALA J, AYACHI, pronounced on 13th of July 2022. The Supreme Court has held that an insurer cannot be held guilty of deficiency in service solely for the delay in processing the claim and delay in repudiation. The facts of the case would be that the insured took a policy of insurance for a sum of rupees 1,62,70,000 covering risks to the mechanical sailing vessel MSV Sea Queen, as the subject vessel sank in the high sea between Oman and Pakistan due to bad weather and rough tides, which damaged the lower portion of the vessel. The insured lodged a claim with the insurer. Since the claim was neither admitted nor repudiated, she filed a consumer complaint before National Consumer Dispute Redressal Forum, which allowed it, holding that the inordinate delay violating Regulation 9 of the Insurance Regulatory and Development Authority, Protection of Policyholders' Interest Regulations 2000, constituted deficiency in service. Being agreed, the present appeal has been filed. The Supreme Court has held that there were two versions, both about the place of incident and about the manner in which the incident took place. The National Commission accepted the version of the complainant solely on the basis of the statements of the 10 crew members made to the customs and the immigration authorities. Since the statement of the crew members of the subject vessel was also corroborated by the rescuing vessel, the National Commission found the version of the complainant to have been proved. But what the National Commission failed to see was that there were more questions that remained unanswered in the version of the complainant and that there were more missing links. First of all, the complainant did not state anywhere in the complaint as to where exactly the mishap happened. Interestingly, the exact place of the occurrence of the incident was mentioned by both the above named persons only in the statements given to the Superintendent of Customs. In the statements made by both the aforesaid persons to the immigration officer, the exact place with longitude and latitude were not mentioned. The marine casualty report contains a column relating to weather conditions. The respondent places reliance upon the said report to show that the vessel sank due to bad weather. But interestingly, the column 47 of the report does not contain any detail except stating that there was rough weather. It may be seen from the above that none of the sub-columns relating to weather direction, force, swell direction, precipitation, etc. in column number 47 was filled up in the marine casualty report. More interestingly, column number 50 to 53 exposed the falsity of the statements made by the captains of both the ships to the customs authorities. According to column number 50 and 51, the incident happened at 4 am local time. But according to the statement of Sri Osman Suleiman Subramania Tandil of the sunk vessel, the entire crew was saved at approximately 10 o'clock in the morning. It is common knowledge that the time of receipt or the source message by the rescuing vessel and the actual time of rescue of the crew of the sinking vessel cannot be the same. Even according to the respondent, the subject vessel could travel only at a speed of 67 knots. Unless the rescuing vessel is in close proximity, the time of the source call and the time of rescue cannot be the same. Thus, according to the statement of Sri Osman Suleiman Suleimania made to the customs authorities, the Tandale of the rescuing vessel heard the call for help in his wireless radio at 10 o'clock in the morning. But according to the statement of the Tandale of the subject vessel, they were rescued at 10 o'clock in the morning. However, the marine casualty report indicates the time to be 4 am on 30th May 2011. This crucial contradiction was completely overlooked by the National Commission. The inquiry by the surveyors with musket radio revealed that no source calls were made from the subject vessel, nor was any response from the rescuing vessel reported. The meteorological departments of both countries, namely Oman and India, confirm that the weather of the specific area coordinates latitude 2340° north and longitude 6143° east was fair. In contrast to the absence of details in the sub-columns of column number 47 of the marine casualty report, the final survey report gives minute details. Another important feature noted by the surveyor is that the normal practice for the Indian road trading from Indian west coast to the Arabian Gulf ports and Yemen, Africa in the month of May is to sail along the coast of southern Oman and after crossing Kuria Muria Iceland and Ras Madrika and set course northeasterly to Gujarat. The skipper of subject vessel confirmed to the surveyors that they also followed the same route. But the coordinates provided by the rescuing vessel showed that the rescuing vessel was positioned at 200 miles north. Therefore, the surveyor was compelled to draw the inference that the subject vessel could not have been in the area where she reportedly sank. All the above aspects were not taken note of by the National Commission. Further, to show that the suspected piracy attack on the vessel could not have been true, the respondent relied upon a ship security certificate purportedly issued by the Mediterranean Naval Security Bureau. Though it was contended by the appellant that it was a forged and fabricated document, this court does not think that this court need to go so far as to discredit the said certificate. The exchange of email about the suspected piracy attack demonstrated at least that the vessel was plying in the prohibited location. Therefore, the Consumer Forum, which has a limited jurisdiction to find out if there was any deficiency in service, could not have allowed the complaint on the basis of sketchy pleadings supported by doubtful evidence. The delay on the part of the insurance company in securing the final survey report and the further delay in issuing the letter of repudiation cannot possibly lead to the complaint being allowed. The delay in processing the claim and delaying repudiation could be one of the several factors for holding an insurer guilty of deficiency in service. But it cannot be the only factor. Therefore, the National Commission was in error in allowing the complaint. There was no categorical evidence of any deficiency in service on the part of the insurance company.